Hey, I'm Nancy Cavey, National ERISA and Individual Disability Attorney. Welcome to Winning Isn't Easy. Before we get started, the Florida Bar tells me that I have to tell you that this podcast is not legal advice. But nothing will ever prevent me from giving you an easy-to-understand overview of the disability insurance world, the games that carriers play, and what you need to know to get the disability benefits you deserve. So, off we go. Do you have ME/CFS or fibromyalgia? Now, I've talked about this disease or these diseases in other episodes, but they're among the trickiest of illnesses to litigate because they're ambiguous, they're hard to diagnose, they're based on subjective complaints, and disability carriers, quite frankly, hate these types of claims. Today, I want to talk about three specific topics. Now, just because this episode is focused on ME/CFS or fibromyalgia doesn't mean that you should just stop listening, because these topics can relate to other disability claims. It doesn't matter if you have ME/CFS or fibromyalgia, MS, Parkinson's, you name it. These are the types of issues that arise in all disability claims. So first, I'm going to talk about meeting the elimination period in your long-term disability policy if you have ME/CFS or fibromyalgia. 2, the 8 reasons used by disability carriers to justify a claims denial of an ME/CFS or fibromyalgia disability insurance claim. And you really have a psychiatric impairment and not a disability insurance claim based on your ME/CFS or fibromyalgia game that disability carriers play. Got it? All right, let's take a break for a moment before we get started. Welcome back to Winning Isn't Easy. The 8 reasons used by disability carriers to justify a claims denial of an ME/CFS or fibromyalgia disability insurance claim. Disability insurance carriers, like First Unum, have a laundry list of defenses that they commonly raise in claims involving chronic fatigue syndrome or ME/CFS. They employ a cadre of medical peer review providers to create these defenses for them. I call these medical providers liar for hire. There's big money for these liars for hires to be made in providing opinions, and big money saved by disability carriers or plans when they no longer have to pay your disability benefits. So let's talk a moment about the role of liar for hire medical peer review providers and how they create reasons to justify a claims denial. Disability carriers or plans always hope at some point that the treating physician no longer supports your claim. And when that doesn't work, or the definition of disability changes, or the carrier is just simply tired of cutting a check, the games begin. The carrier is going to assign your file to a nurse case manager or a peer review provider to determine your correct and accurate restrictions and limitations so that they can justify a claims denial. Doesn't matter what your doctor has to say. The medical providers are either on-site physicians employed by disability carriers, in other words, doctors who can't make it in the practice of medicine, or are medical providers who have signed up with disability review companies to supplement their income, to help pay for their malpractice insurance, or their next big vacation to Italy, or their Lamborghini. Either way, they're generally nothing more than hired guns. That's why I call them liar for hire medical review providers. Now, it's not uncommon at some point for this hired gun to contact your treating physician to seek a better understanding of your doctor's medical opinions, to persuade them to change the restrictions and limitations so that the carrier can take the position that you're capable of working and we don't have to pay you anymore. Okay? So what are the 8 common reasons for denial? Number 1, no correlating findings. Medical reviewers will criticize the treating physician's records on the basis that there's an absence of correlating findings or studies that substantiate your reported complaints or physical exam findings. Now, that's code word for I've just cherry-picked your medical records. I've ignored the objective findings that explain or are consistent with the disabling symptoms. I'm just going to ignore those because they don't help me justify this claims denial. Denial reason number 2, an absence of functional impairment. This reason always amazes me. Look at your disability policy. Do you see functional impairment as the definition of disability? Rarely. And rarely do you even see a blasted definition of functional impairment in the denial letter, because they don't really know what it is other than it's a made-up term that they use to deny claims. Does the peer review doctor ever explain the standard that they're applying in determining whether or not there is a functional impairment? Rarely. Another game the carriers play by creating this policy term that doesn't exist. Denial reason number 3, unremarkable lab findings or diagnostic studies. Now, peer review physicians will often equate normal laboratory findings or diagnostic studies as evidence that there isn't any impairment. And it's not uncommon for there to be negative lab work or diagnostic findings in the case of ME/CFS or other diseases. These medical conditions generally can't be established through objective medical evidence other than a physical examination that might show the appropriate number of tender points. And the peer review providers know that, but that doesn't prevent them from hanging their hat on the lab work or the diagnostic studies as a reason to justify a claims denial. Denial reason number 4, there is medical improvement. So on the flip side, the medical reviewer is going to look at your medical records and they're looking for comments like the patient reports that they are improved, the patient reports that they are fine, the patient reports that they're doing better. Please, please, please don't use any of those terms when you see the doctor. That's the time to unload on your doctor all your symptoms and how those symptoms impact your function. But the medical reviewer is going to jump all over those words and conclude that there is improvement. Now, it doesn't matter whether that improvement is temporary or permanent. They're just going to focus on the word improvement. And you're so improved that you could return to work. Now, of course, that generally isn't the case, but those words can come back and bite you. So don't use those words. Denial reason number 5, the level of care is not sufficient. Is your head spinning yet? So the medical reviewers often will comment that the lack of escalating care or medication is inconsistent with a reported level of impairment, pain, or fatigue. And as a result, you're capable of working. Now, that's an argument that I always like to attack by having the physician on appeal address the level or nature of the treatment. But I think that unfortunately is a common reason that liar for hire peer review doctors use to justify a claims denial. Now, of course, they're not the one who ultimately denies the claim. They're the people who are creating the ammunition with which to deny the claim. Denial reason number 6, there are no side effects of medication. Now, I know that medication for treatment of ME/CFS has numerous side effects that can impair your functionality. There's Benadryl, Zoloft, lorazepam, Adderall, Lyrica, all sorts of medications that have known and reported side effects. And you're probably taking multiple medications. Now, peer review providers are going to scour your medical records looking for medication side effects. If they don't see any, they're going to think that there aren't any side effects that would give rise to a level of impairment warranting restrictions and limitations. That's not the standard of disability either. And they purposely fail to address the known side effects caused by the combination of these medications. So they'll take silence in your medical records as meaning that you have no side effects or that they aren't disabling. So please, if you're having side effects, report them to your physician and make sure that you're noting them on any activity of daily living forms that you're being sent by the disability carrier. Denial number 7. There's no objective evidence of the diagnosis. And of course, their position is this is all subjective. And they'll argue that doctors always rely on the complaints of patients regarding their opinions about the diagnosis and the restrictions and limitations. That's just the nature of these types of medical conditions. It doesn't matter if it's ME/CFS, fibromyalgia, migraines, mental health issues. If that was the criteria for disability, nobody would be entitled to their disability benefits because there's generally not objective evidence to confirm these diagnoses. But I will tell you the courts across the United States have repeatedly criticized and reversed denials based on a claimed lack of objective basis for the diagnosis. Nonetheless, if there is an objective basis, I want to see it in your medical records. if there are diagnostic studies or physical exam results that correlate with your complaints, we want the doctor to comment on those. And denial reason number 8, there's no objective evidence of the restrictions and limitations, and your treating physician is improperly relying on your subjective complaints, and therefore he's not believable, and neither are you. Now, this defense has some traction with some courts. They want to see an objective basis for the restrictions and limitations. Courts uphold these types of denials, and I often recommend a functional capacity evaluation or a cardiopulmonary exercise test or comprehensive neuropsychological testing in the case of cognitive impairment. Courts will recognize these tests as objective basis for the assignment of restrictions and limitations. So, what should you do if your claim has been denied based on one of these 8 reasons? Now, you need to understand if this is an ERISA case, you'll only have 180 days in which to file an appeal. The appeal is the trial of your case, and you should be taking on every one of the purported reasons for your claim denial. In my office, we write appeal letters that are 25 to 65 pages long. They're filled with medical evidence, legal evidence, vocational evidence. We send them in as a shock and awe appeal, and we take on all the reasons for the claims denial and even things that they have missed in terms of their denial that may not be mentioned in the actual denial letter, but may be discussed in the adjusting notes. We got to take them on because that appeal is the trial of the case. Once the appeal process is completed and you've exhausted your administrative remedies, file a lawsuit. You can't add anything new. Now, most lawyers don't understand that. They think that this is like any kind of civil litigation and they can hold the best evidence till trial. That will destroy your case. So you need to understand that if you get a denial letter for one of these 8 reasons, or all 8 reasons, or even reasons I didn't list, you should be consulting with an experienced ERISA disability attorney to help you file an appeal. Got it? Let's take a break.